have an opportunity here to provide leadership, support, and a voice to the voiceless. The sacrifices that we made during our service do not end here. We carry on. We push forward, and we give hope and inspiration through love, community, and support. Stay free.
Rights and freedoms in this country are absolutely everything to me, because I personally know the sacrifice required in order to get them back once they're gone. So when my brothers and sisters call Stand 2, be sure I'll be there.
Legacy media will play their games, right? Like, this isn't about this or that. This is about freedom, period.
The only thing necessary for evil to triumph is for good men to do nothing. Brothers and sisters in uniform, whether you're a police officer, military, check your hearts. Look where we're going. Man, wake up. I beg you.
If the veterans can't stand up and get a message across to the government, I don't know who can. I don't know. But we're going to give it our best shot. And I think we have a chance to win this and do it. But we need your help. And we need you to come, and we need you to stand too. Thanks for listening, everybody. We'll talk again soon.
Got a sunburn to peel the daggers off your tongue. Young and dumb, I'm rotting like a bed sore in a cold case that's never gonna be more than scratching at the walls while you're waiting for a bullet to come. All along I've been treading in the deep end, throw my mirror in the cupboard for the weekend. Try and put together pieces while I'm dreaming, but nothing's adding up to a thing but a hole in the head. past their rabbi, sold out to the merchant shelves. Minutes after they took out from the bottomless pit, my head was made strong by the hand of the Almighty. We forward in this generation triumphantly. Won't you help to sing these songs of freedom? It's all I ever have. Redemption songs, redemption songs. Emancipate yourselves from mental slavery. None but ourselves can free our minds. Oh, have no fear for atomic energy, 'cause none of them can stop the time. How long shall they kill our prophets while we stand aside and look? Some say it's just a part of it. Got to fulfill the book. Won't you help to sing these songs of freedom? It's all I ever have. Redemption songs, redemption songs, redemption songs. Emancipate yourselves from mental slavery. None but ourselves can free our minds. Oh, have no fear for atomic energy, 'cause none of them can stop the time. How long shall they kill our prophets while we stand aside and look? Some say it's just a part of it. Got to fulfill the book. Won't you help to sing these songs of freedom? It's all I ever have. Redemption songs, redemption songs. It's all I ever have. Redemption songs, redemption songs, redemption songs.
Hey, what's up, troops? Jeff Evely, the magnanimous Gen Xer male, I'm back with you now on this 7th day of February 2023. Got a great show lined up for you today. Back with us today is William Ray. He's another veteran bro, veteran of Medic Pocket, and he's been pursuing a lot of legal action against the province of Nova Scotia in conjunction with Citizens Alliance for Nova Scotia. There are corporate entities that stood up to fight back against all this tyranny. So, they were recently in court there. And of course, the province is up to the usual tricks, trying to get everything dismissed and sweep it all under the rug. And I'm looking forward to having this conversation actually, because, I have an appearance in court coming up very soon with respect to a mask fine that I received in 2022 of January. So we're just getting to that now. And also I filed some of my own notices for judicial review with respect to some of the heavy-handedness on the part of the province, most recently during the Nova Scotia so-called wildfires, which we know were actually arson attacks. And here in Cape Breton, I couldn't walk my dog in the park after 3 days of rain, because if I drove 8 hours, then I would get to a wildfire. So before I bring William in here, I'm going to go ahead and say good afternoon, good morning to everybody. Good day, I guess, is the way to go here. But here's James Bullock, first guy on the board, says, looking forward to the further insight on a rugby doctor's tyranny in Nova Scotia. Yeah, no kidding. That is Dr. Strang's background, by the way. He was only ever a practicing doctor for a rugby team once upon a time. So, yeah, we're being tyrannized by morons. Here is Friday Terry giving us the triple slashy, and Binks Wilbeth is doing the same triple slashy to all you folks out there. Binks Wilbeth says, Dr. Strang, big pharma enforcer. Yeah, I think that's the case with just about everybody. Big pharma has got its tentacles into everything. I saw something, I believe it was 80% or 70, maybe 70 or 80% of Public Health Agency of Canada's funding actually comes from big pharma now, because they make them pay for the approvals of their drugs. No conflict of interest to be seen anywhere in any of this, of course. Susie is saying, anxious to know what was discovered in the foy pops to prove Strang is intentionally harming Nova Scotians. Concerning, yeah, I'm going to be having another live stream next week, actually, to kind of hone in on that. Paul Westhaver has been a driving force behind a lot of these foy pops. And he's the guy who helped Shelley Hipson get her website up and running as well. She's very well known for these foy pops. So we'll be honing in on that in the coming days. Chris Freestone is with us, ladies and gentlemen, giving us the triple slashy. And here is Mother the Drummer saying, good afternoon, Jeff and Chad. Got my coffee and ready to go, as do I. Awesome to have you on board, as always. Andrew is here saying, good morning, Jeff. Good morning, Patriots. Triple slashy. Drink your milkshakes. We have all the reason to celebrate for the wins the movement is making. Yeah, I believe that's a reference to a couple of the Coots 4 boys being released. You know, what I've seen so far, it looks like they pled guilty to some of the lesser charges, like improper storage of a firearm, which, by the way, is usually an accident. And a lot of the firearms regulations in Canada are really there to deter us from owning firearms, because as I'm sure our regular viewers understand, you're not really allowed to defend yourself in Canada. It only just kind of says that on paper. So, and here's Friday Terry saying, I think we should make oppositional defiant disorder normal again. Yeah. I tend to agree. I suffer from it. And Big says, I am VE for the win. All right. And Darlene says, good afternoon, everyone. I'll be listening in, but won't be responding. I am sick. Oh, well, I'm sorry to hear that, Darlene. Hope you feel better soon. But thanks for always being with us from New Brunswick, I know. So it's great to have the Atlantic Canadians on board, as usual. And Cindy, our most faithful of all watchers, says, good afternoon, Jeff Hart's afternoon, friends. And she's given us the victory, which everybody thinks is a peace sign, but it was originally made famous by the GI generation in World War II, as was the Jeep wave. That's what they would do as they were passing each other, is give each other the Jeep wave and the victory sign. I mean, Richard Nixon used to do this. He used to do the two-finger victory sign that everybody thinks means peace these days. And he hated the hippies. You should read some quotes from Richard Nixon about the hippies, or any quotes from Richard Nixon for that matter. He was extremely based. It's pretty funny to read, especially in light of the era in which we now live, where everybody's goddamn well woke. Okay, and Shiloh's over on Rumble saying, good morning, Sergeant Major. So much news late yesterday. Do you think the case outcome with the 2 of the 4 still in captivity in Alberta will affect the ongoing litigation still before the courts across the country? You know, I think that the tide is turning, and I think that a lot of the decisions we've had, like there was the Emergency Measures Act, judicial review that declared it Ultra Vires, and now the tone has shifted, I think, and now we have this momentum that we can see building with the Coots 4. So the momentum is shifting in the other direction. So that's what I'm seeing, is basically it's going to be an attitudinal shift, and maybe they'll think twice before they just kind of dismiss us out of hand in court, as they have been. And Estia Rolani is with us, ladies and gentlemen, saying good morning, everyone. And Slabtown Gal is giving us the triple slashy. Okay, guys, good day to everyone. Thanks very much for being with us. I'm going to dive into this before before William gets mad at at me for making him wait for too long. All right, here is our philosophy quote from the day. This comes courtesy of Plato, and it says, "The worst form of injustice is pretended justice." I think that can resonate with just about everybody, especially those of us who have been engaged with the courts lately. Like they pretend to provide justice, but really, I think it's a foregone conclusion the majority of the time. But as I have been saying, the courts are the key battle space right now. It's not to dissuade anybody from demonstrating or doing any of that awareness raising, but the battle space has shifted away from that toward the courts, and we should be leaning into that right now, standing on some of these decisions like the declaration of the Emergency Measures Act being ultra vires by the federal courts, so on and so forth, to bring a tidal wave of lawsuits against all of the people who did this to us, especially if we can show that they were acting in good faith, because then they're not going to be legally protected for the decisions that they made in while holding public office. Now, normally you are protected legally from those from being sued for those decisions, but if you're acting in bad faith, that's another matter. So we'll talk about that with William when he comes in here too, because I'm sure he's got a lot to say about that with respect to Dr. Strang. Here is Dr. Strang, the quote unquote father of Nova Scotia, just for those of you who may not be familiar.
'Twas the night before ride, and at the start line, the event grounds were ready for a roaring good time. Riders thrilled to be reunited with teammates and friends, and the chance to ride safely in person again. Helmets were left by their front doors with care, as a gentle reminder to not leave them there. And proper footwear too, so your feet don't slide. Save the Costco sandals until after you ride. Whether on the trail or the road, you can't travel in packs. Bike in single file.
All right, that's about all of that I can stand, but I think you guys get the idea. I mean, these people, our public health officials, our senior officials, they think we're all children, and they need to wrap us in bubble wrap in order to quote unquote keep us safe. I just find like life involves risk. Okay, there's always a risk with any decision that you take, and it's my risk to assume, not Dr. Strang, so he can piss off. And here is Dr. Strang. This is Laker News. Pat Halley. He's tweeting out, "Congrats to Dr. Robert Strang, Fall River, Nova Scotia, for being one of 11 recipients awarded the Order of Nova Scotia by Lieutenant Governor of Nova Scotia, Arthur J. LeBlanc, on March 28th. Yay, good for you, Dr. Strang." And here is, I think, a better photo of him here with J.R. Hartley. He says, Nova Scotia's Dr. Strang knows more about baby roots than he does medical issues. Yeah, that's a nice close-up of him right there. Okay, and for those of you just listening, this is the shot from the Goonies there. Geez, what's this guy's name? He looks like an ogre anyway. Slav, something like that. I can't remember, but he got dropped on his head a whole bunch of times anyway. Okay, I have been making William wait long enough. I'm going to bring him in here. How you doing this morning, brother? Thanks for being with us. Uh-oh, we got some We got some issues with your audio already, man. I think I remember this happening before. You have a really bad buzz there, but it seems to be intermittent. I'm not sure what you're doing, but it's gone now. Now it's back.
Is that better?
Yep, that's better. That's perfect. Clear as a bell.
Okay.
All right, William. So I kind of gave you the brief introduction already, but for those of you who aren't familiar, please feel free to kind of spin us up on what you've been doing and maybe give a brief service history while you're at it.
Sure. Well, I was in the Army many, many moons ago in the Brontosaurus division there. And so I ended up with 2 PPCLI in the Medak pocket. I was an artilleryman, though, by trade. And so, yeah, now I am a board member of, and the litigation agent for the Citizens Alliance of Nova Scotia. We went into court October 27th, 2021 for judicial review. That was within 30 days of Robert Strang introducing the vaccine mandate here in Nova Scotia. which was contained in an iteration of his public health order and an embedded protocol. He didn't actually spell it out within the text of the public health order. It was in an embedded protocol that came with it. But essentially, yeah, it stopped people from working, from participating in normal society if they did not show proof of vaccination. It was used to lay off a bunch of provincial workers like we saw all over Canada.
Right.
So after a couple of iterations, what we are alleging is that Robert Strang acted ultra vires to his home statute, which is the Nova Scotia Health Protection Act, which states at section 53 2A, and I quote, that the Chief Medical Officer of Health has the power to institute a voluntary vaccination program in Nova Scotia or any part of the province. Obviously, we say that is not what he did, because the legal definition of voluntary, it cannot be coerced. And indeed, the mandate system he set up, where every business and organization in the province was mandated to enforce vaccine ID, that you had to show proof of vaccination, full vaccination, which I believe at the time they called 2 shots. So, along with that, that is our principal allegation, and that is very much in line with the recent finding of the federal court on ultra vires. They found the federal government ultra vires on its use of the Emergency Act. So our secondary, I suppose, claim here is that he acted, and it is what they call inter alia. It is interlocked with his ultra vires action, that he acted in bad faith, both in knowingly going beyond his legal restriction and trying to do so through his embedded protocol, and also by the fact that leading up to it and during the decision, he exhibited bad faith action in that he had there was no way he could form a reasonable belief that the vaccines were either safe or effective, and which is indeed what he was asserting the entire time. So that's the base. Our relief asked for is, we are asking for judicial declarations that he was ultra vires and that his mandate had no effect in law from the start, ab initio, from the start. We are also asking that for a judicial declaration that he acted in bad faith, and what that has the effect of. So, as you mentioned in your intro, he enjoys what's called limited liability protection, as do all civil servants, soldiers, policemen. But specific to the Nova Scotia Health Act, at Section 12, it states that the Chief Medical Officer of Health and any public health officer enjoys limited liability protection from civil or criminal action for any actions taken under this act in good faith. So, if we get a declaration he acted in bad faith, he will no longer enjoy limited liability protection, and any person harmed by his action could sue him directly or swear out a criminal complaint, and they would not have to get past that. We also asked the judge for an injunctive relief, to say that the province could never in the future institute anything but a voluntary vaccination program. In the hearing on the 24th, though, the judge indicated that this was not something that, not that he wasn't prepared to do it, but that he couldn't do it. His words were, "I cannot injunct the government from doing a thing it has not yet done." So we will strike that claim, and we will rest on the what they call declaratory relief, that the judge say it was ultra vires and that he acted in bad faith, and we'll
Okay.
go from there. So that's in essence. On the 24th, we had a hearing for public standing. Now, I'm going to pin this a little bit. I don't know if anybody saw it. There was a CBC article that actually came out about us and this hearing. It was,
Yeah.
if not the worst piece of so-called journalism I've seen in a decade, it was close. He literally didn't get one thing right, and apparently was listening to the whole thing. So the reality is, my organization, the Citizens Alliance of Nova Scotia, and we have a minor co-applicant that I can only identify as JM, a young man who is prevented from playing hockey and doing other things because of the vaccine mandate. We both have what's called private standing. So our matter will be adjudicated no matter what happens, whether we are or are not granted public standing, because we were directly affected. So was a minor applicant. We can pursue, it will be more complex, but we can pursue everything we're asking for between us and the minor applicant. We believe, though, that this is a matter of public interest. It was not simply the Citizens Alliance of Nova Scotia who was wronged by the actions of Robert Strang. It was the citizens of Nova Scotia. So that's the, oh my God, this guy got everything wrong. He missed, even though apparently he was listening to it. And during the hearing, the Crown admitted, in fact, the Crown based a lot of their argument against us for public standing on the fact we already have private standing. The Crown's argument being, well, they can already be here. They don't need public standing. That was his whole argument. Yet this guy says that we're there because if we don't get public standing, we get booted out of court. That's not right.
Right.
He misquotes the section 53 at both, because he calls it section 52. Now, they may have corrected parts of this if this is their current version, because we sent them a stiff letter. But initially they misquoted the thing entirely.
Yeah.
And deliberately in one respect, because so it's 53(2)A says that he can only do a voluntary vaccination program. And then
Right.
there's
We just showed that.
there's a list of other things that he can do. At the very end of the list, I, so this is 53(2)I, says what it actually says is that the chief medical officer of health may do any other thing other than the things in that list that he thinks is required. The journalist originally quoted it as saying that the chief medical officer of health can do anything that he thinks,
that is what it says right here. It says another part of Section 53 states that the chief medical officer can establish any other measure they believe is reasonably necessary for the protection of public health during the emergency.
They changed that. They changed that. They changed that. That is up at the start of the act, but that's the nature of legislation. It starts out broad and narrows itself. So that little bit in the preamble doesn't help them at all.
Right.
What they originally quoted was that they said that 53(I) said he could do anything, when it actually says he can do any other thing. Like he can do stuff that isn't in this list. That's all it needs.
Yeah.
So they did correct it, I guess, partially. But we had a very good hearing. Obviously, now we've waited 2 weeks for the decision. So that means, the judge, if he was going to fine for the Crown, he would have done that quite quick, as unfortunately,
Yeah.
Yeah.
So, I do know. So William's making reference to a judicial review that I filed during the Nova Scotia wildfires, or in response to the over broad restrictions that they put on Nova Scotians during that. Like, we're the only jurisdiction that even did that.
I've never heard of that in my life. And I come from Alberta, man. We get some badass wildfire up there.
Oh yeah, it's the first climate lockdowns in history,
Sure, but you don't lock down people in Calgary because Fort McMurray's burning. You know what I mean?
Right.
That's ridiculous.
Well, and here I am in Cape Breton. I even had on the day that we showed up, they brought somebody from the province there, and you know, just going by the legislation, I was like, well, did a conservation officer declare that the municipal resources in the Cape Breton Regional Municipality were insufficient to fight a wildfire at that time? Because it says, like, then this is what they do, folks. It says in one section, in an earlier section, that if that happens, if a conservation officer makes that declaration, the municipality who has the primary responsibility for fighting the blaze, it has insufficient resources, then the minister can step in and allocate all of these other resources. But they'll look to a later section that says that the minister can do anything that he deems necessary to fight the blaze. And I'm like, well, he didn't meet the criteria to start invoking all of this stuff to begin with. But it sounds like the tactics are very similar to what you're doing. Well, I mean, at least with respect to the Crown's approach, or the CBC's approach anyway. But is this the approach that the Crown is taking? Are they sort of cherry picking one section of the Act that's stated broadly, even though there are other criteria listed in the Act?
The Crown itself actually hasn't responded that much directly to our base assertion. I don't think they have a good response. But what the Crown did do, and I think interesting in regards to your case as well, the Crown spent a lot of time arguing that we don't have any money and we don't have a lawyer. So therefore, I mean, come on, they can't be in court. He spent a lot of time saying that. And I think, yeah, with self-represented litigants, which I think is the wave of the future. And you know, I've read the decision the judge gave you, and I mean, to my view, there are several reviewable points. There are several appealable points in his judgment. Because some of it, because yeah, okay, like an administrator can do certain things, but he has to always act within reason.
Yes.
And there is a generalized burden put on administrators called the dore duty, which means whenever they make a decision, they are supposed to take the charter into account, and they're supposed to do the least insulting thing they can. And obviously, they've gone to the other side of the scale because, yeah, for anyone not familiar, there was a arson set fire in Shelburne County, which is one county in Nova Scotia.
Right.
And they kind of let it burn. They don't have any forest firefighters, but the workplace comp rules won't let the volunteer firefighters or the municipal guys go fight it. And they don't really have the equipment. So they let this get way out of control and then said that no one in the province could enter any, you know, Crown owned lands, any parks, any, you know.
Oh, it applied to private land too. You couldn't enter the woods.
Oh, I missed that part.
Oh, yeah. Yeah,
Okay,
unless you
yeah.
ask for special permission, and then we're
So
back to papers, please.
under the Valvanoff decision by the Supreme Court of Canada, this was an immigration thing, RB, and for any of you self-litigant thinkers out there, look in immigration. The courts like that, so they rule. But yeah, so in this case, they set a new standard for judicial review in Canada, which is reasonableness. That the decision has to be reasonable. Not only that, but the steps that the decision maker has to show how they reached the decision, and that has to hold together in a reasonable, logical fashion. So, you know, like you brought up a very good point that this power was being used completely unreasonably, and I think you were correct.
Thank you.
Yeah, for sure. And I think it's
Um,
very important that people like us go in and do this because, you know, like you say, there's the appearance of the thing without the thing because they say, well, everybody got access to justice. But I mean, you're looking at $100,000 to mount like for what we're doing, the review we're doing, we would have spent $100,000 by now.
Right.
Easy.
And that
who
is,
the hell can do that?
I mean, and even in, because I think you may have read my original submission too, but in that, so what the Crown will do is they'll kind of attack the self-represented litigant as wasting the court's time because you know they'll they'll attack some of your arguments and say this is erroneous and that's erroneous. This just goes to show what a waste of time the self-represented litigants are. If they would just hire a lawyer, then we wouldn't have to deal with this stuff. And I just came right back at them with like Supreme Court justice articles right off of canlea.org, which is a fabulous resource for anybody out there who's interested in self-representing. There are these papers and articles from Supreme Court justices who will say like the primary barrier to justice in Canada is the affordability. They do
a lot of talking about it, but they don't make a lot of substantive change. You know what I mean? Like, but yeah, they do a lot of. So it does help. You're right about that. I quoted some of the same stuff you did for sure. In my oral argument to the court at one point, in the closing, what I said was that we reject the idea that the courts are a temple, that only the priesthood may enter, and that the citizen must pay a heavy indulgence to have their prayers heard. We reject it. We say that the right to redress against the state rests with the citizen, not the citizen and council. This is something that's developed over time, but the initial, guarantees of the Magna Carta and the Canadian Constitution are rest within the citizen, not you and your lawyer.
Yeah, and the reference to reasonableness that's even right here in the CBC article. It says the chief medical officer can establish any other measure they believe is reasonably necessary for the protection of public health during the emergency. Now, there are two parts to that I find interesting, because reasonable is like a reference to Section 1 of the Constitution, that any measures the government imposes to restrict your freedoms must be reasonable and demonstrably justifiable in a free and democratic society. So where have they demonstrated the demonstrable justification? Where is the demonstrable justification for the measures that they've imposed that restrict constitutionally enshrined freedoms? And they never do that, of course. And the other part, here is it says of public health during the emergency. I mean, was an emergency even declared in Nova Scotia?
There was a state of emergency declared by the Minister of Housing and Transport. One of the things we're saying, it's a technical breach, but again, that's what was won at the federal court level, was a very technical breach of the law. So technically, Section 53 out, I think 59. I don't want to, but at the start of Section 53, it basically says that that the chief medical officer of health is actually supposed to make a separate declaration, like he's supposed to declare a health emergency. And technically, that we find no evidence that happened, and the Crown has not actually asserted that it did. And so that even the voluntary vax program without that declaration might be a technical fault. I would say, though, the Supreme Court, the federal court in their recent decision, and we are starting to see those. There was an arbitration decision in BC about Purolator, where employees won against being fired by the vax pass. And the important part about it is that the employer tried to point to public health, and the arbitration panel said, no, you did this as a third, you did this yourselves. This was your corporate policy. You cannot just put it on the shoulders of this guy, especially because the public health mandates for vaccine ended, but all the employer ones, all of that carried on, and they never would have existed without the initial public health order. So they are, we say, effects, direct inter alia effects of the public health declaration. But I think we have seen a very spotty performance in the courts. obviously relying on the Constitution, and that's why, like, I put the original I put in the original claim on this judicial review. Like, I wrote it without a lawyer because at the time we couldn't get a lawyer to sign it. None of them would do it, wouldn't do it. Right? We were talking to a couple who work for big firms in Halifax, and they said, if I sign this, that's my job. Like, I'll be out of there tomorrow.
Right.
You know, and that came from the bar. So it was, and I at one point in my oral arguments on the 24th, I said that, you know, that the respondent was showing a rather Hegelian argument here, because they say, oh, well, the matter's taken 2 years and this and that and the other, and they don't have a lawyer. I said, well, you know, these conditions were in great part caused by the respondent, right? It was in reaction to the respondent that the courts damn near closed down, that the Bar Association issued directives that meant that, yeah, if you took a case like this, your employer could fire you and you might even get disbarred. Right?
Right.
Look at all the doctors that lost their licenses for saying anything. Right?
Constantly. I mean, Dr. Trozy just lost his license there recently too.
Doctor who?
Trozy?
Oh, I'm not aware of the case.
Yeah.
Is that
Yeah.
here in Nova Scotia?
No, I think he's in Ontario, but
Oh.
he's been very outspoken throughout the whole pandemic, especially as it pertains to the real science. So
Oh, sure.
yeah,
And it, you know, like, they created a a cute little centipede, informational centipede, because in the Crown's written submissions and oral, or, you know, written submissions, I think he made the argument that well, you know, the courts of Nova Scotia have taken judicial notice that vaccine is effective and safe and yada yada. And they did, in a case where they were releasing a bunch of criminals because, oh, too dangerous to be in jail. So, you know, but I made the point, like, we're alleging that the respondent's statements on this matter were made in bad faith, including to the justices. So you cannot then rely on pronouncements made by the justices because of what we say are bad faith utterances of the respondent. Like,
right.
you see the circle there. I'm like, no.
Yeah. Circular reasoning.
Yeah. So, we had a good hearing. The fact that the judge, you know, obviously he's taken time to reflect on this. But whether we win or lose at this, we keep going. Our next challenge is mootness, but we believe, we are very confident that we will defeat the Crown's motion for mootness, because we're not making a constitutional argument. And all the ones that all got struck as moot, they were all constitutional. The federal court case went ahead because it alleged unlawful behavior, which is ultra vires behavior. It's not exactly the same, but an easy way for people to understand this is that, you know, like, if I went out and committed some sort of crime, I go rob a bank, and, you know, I stop robbing the bank at some point and I leave, hopefully apologize to everybody for the inconvenience and trauma. I'm then arrested by the constabulary, brought in front of the judge, and I say, oh, well, you know, the matter's moot. I'm not robbing the bank now, am I? It's over.
I know.
Right? I mean, so that's, you know, it's a criminal thing, but the basis for a criminal charge is unlawful behavior, and it's no different in administrative law. If someone is ultra vires, then they acted unlawfully. So we're going to, you know, that's the base of our argument, is that this matter is not moot. We're not having we're not building theoretical constitutional argument constructs. And like, part of their argument was that, you know, this is, the courts. I mean, my God, these peasants over, and I'm paraphrasing here, but basically, you know, these fucking broke ass peasants over here should go home and shut up. They don't have the intelligence or the education to be here.
That is the attitude.
Absolutely. Well, and it's everybody in the room except you has a fiduciary interest in that remaining true. Let's be clear on that, don't they? Right? Because what are judges except ex-lawyers? Right? And the lawyers that charge $300 an hour. I mean, there's only one other profession I know of, brother, that charges $300 an hour, and they usually wear high heels and lingerie when they do it. I'm not going to make any kind of moral comparison there. Y'all do what you like, but that's a fuck of a lot of money for thinking
Yeah.
of some shit and reading
Yeah.
some rules. That's a fuck of a lot of money. And if the population, like, I don't know if he's still sticking with it, but way back, Polyev said something about, going through the law and making it in plain language. Because, yeah, I mean, if it was in plain language, because that is huge. The language is very opaque. It's very complex. You have to look in 3 different places to get the rules for one thing. But it's not, once you get the hang of it, and I think you'd agree, it's not rocket science.
No, it's
No,
definitely not rocket surgery.
no. And
It,
the online, like you mentioned, Canly and the various other online resources are amazing. And it's the
yeah.
same shit your lawyer's doing. What you fucking
Yes.
think your lawyer's doing for $300 an hour, man? He on Canly going do.
Yeah. Reading, research, logic, like
Sure,
it's
sure.
definitely not
So
rocket surgery.
yeah,
It helps to have that familiarity with the law, like
sure.
and I've seen this, quite a bit throughout the course of this crisis, where a lot of people are making this argument from common law, and I'm a good kind of self teacher. I can learn as I go, and think on my feet and stuff like that. So I'm lucky in that regard. But one of the things that I learned throughout the course of this would be, for example, a lot of people they're standing on the common law, and all that really means is the English common law tradition forms the foundation of our legal system. But that doesn't negate the fact that there's an entire structure built up
You can
over
refer
that.
to it. You can refer to it. I mean, I quoted the goddamn Magna Carta at
Yeah,
section 40. To none will we sell, to none will we deny or delay right or justice.
yeah.
So you can refer to it, but no, you can't rely on it. No,
It doesn't invalidate the structure that's built up on top of it. And really,
no,
like, what makes it common is that we can actually use case law from other jurisdictions like the United
yeah,
States and Australia and Britain as precedent, right? We can use those to cite precedent where applicable. So it's definitely advantageous in that regard. And also, like, there's a lot of people making the argument from the Bill of Rights, but apparently, and I got to understand this throughout the course of preparing my own arguments. The Bill of Rights is because a right, people, first of all, they conflate rights with entitlements. So they think that a right is something that the government gives you, but really a right is a freedom that you're born with innately, that the
yeah.
government may not interfere with. And the Bill of Rights is the bill that restricts the federal government's ability to interfere with your rights, but it doesn't actually apply to the provincial governments.
Useful
But
in federal court, though. You can use it in
yes,
federal
absolutely.
court, certainly. And
Absolutely.
and
Yeah.
there are any citizen of Canada can launch judicial review of any decision in the federal court of Canada for a $2 filing fee.
Yeah.
So
Yeah.
yeah, so yeah, for self-represented litigants, for sure. I think you've got to go in. From my experience, you've got to go in with this mindset. Some of the rules may suck. You may not agree with them, but they're the goddamn rules, and they're not going
Yeah.
to change the rules for you. So you better learn them enough and understand them. And you need to get an understanding of what's behind them and why they're there.
Yeah.
And yeah, like, so one of the papers I read about self-represented litigants, one of the big complaints and the things that'll get you booted out of court real fast is if you get in there, you encounter some rule or something that doesn't work for you, you don't like, and you start fighting the rule,
Right.
that they'll show you the door,
Yeah.
right? So
Yeah. The trick here is to beat them at their own game.
yes, exact. And certainly these laws were written by people who were not, who were not engaged in what our political class seems to be engaged in at the moment. So somebody, when they wrote the Nova Scotia Health Act in 204, somebody thought it was important to stipulate voluntary immunization.
Mhm.
So that's, That's so we're relying on that, and we say it's prima facie, and the Crown has not mounted an argument about that yet. They've argued us about many other things. Next, of course, is mootness. They say because things over. We're very confident on that, and after that, once we get to the review, I don't see what he's going to say.
And the mootness argument is so I had my judicial review dismissed on mootness because they said there's no fire now, so these measures are no longer in effect, and therefore it's purely hypothetical. Now, this was something that I addressed in my written arguments as well. This was like before we ever got there. I don't think that the judge made a very good decision. He didn't address the arguments that I put forth directly or anything like that. It was I found it to be pretty dismissive the way he wrote his decision, but
Yeah, he called you hyperbolic or something like that.
he said I used florid language, and
Lord,
yeah, can you imagine florid language? Me,
fancy
of all
language
people.
in a court,
Oh yeah, imagine that.
right? Like you assholes are continually saying whacked out high school fucking Latin. Yeah.
Yeah,
Anyway, go
yeah.
on. Please.
Oh, but yeah, they made the argument that it was purely hypothetical because there's no reasonable expectation that this kind of decision will be taken again in the future, and they cited case law from I believe it was in Ontario where the province had declared a certain territory to be a provincial park, and then they were taken to court because there was insufficient public consultation, essentially, and it was ruled moot because it's not affecting them now. There's no reason to expect that it's going to happen again in the future. But as I pointed out, yeah, that would be moot and that would be hypothetical because the designation of a provincial park is a purely administrative decision that's made entirely in a vacuum, and it's not in response to emergent circumstances such as a wildfire, which is seasonal, where we can expect that there are going to be more forest fires in the future because of the seasonal nature of wildfires. And I would say that that applies to pandemics or new viruses generally as well. So they want to make this argument that it's purely hypothetical and there's no reason to expect that it'll happen again. But it's like, well, the pandemic and or wildfire are the reasons that we should expect that this kind of decision will have to be arrived at some point in the future. And so, we should rein in these people when it comes to their proper
Well,
decision making. Right?
they're very what I found in putting together my argument against mootness, and I said this earlier. If you, when you're doing CanLII searches, if you tag the words immigration or conservation, call any of the green buzzwords,
Mm-hmm.
um,
Yeah.
you will get a
Speaking
lot
of beating them at their own
of
game.
you'll get a lot of, like, I found decisions of the federal court that said, because one of the tests for mootness is that there is a live conflict, that the conflict is still
Yes.
ongoing, or that it's important enough to put before the court. So, in terms of live conflict, I found federal court decisions that say a live conflict exists between the government of Canada and a person who is not a citizen of Canada because they were denied a visa but may want one in the future.
Good Lord.
Oh yeah. Oh, and I got a laundry list of them.
Yeah.
And I'm gonna lay them all on the Crown because that's a precedent.
Please,
Right?
let's compare notes.
Isn't even a citizen who may in the future want to come here. That's a live conflict. But the the Peckford got struck out of the Fed court because
Exactly.
what? So
Federal. That was
yeah,
the travel
so,
restrictions were no longer in effect.
yeah. So I don't know if Peckford's lawyers didn't look under the immigration banner because there's a lot of case law that supports it. And of course we say in our case, this goes beyond even the travel ban. And during the oral arguments, the court, seemed to accept this, that, we're talking about the invasion of the corporal body. We're talking about the forcible injection of an experimental. And here, interesting little side note for reviewers. In all written and verbal arguments, we have continually referred to the vaccines as experimental mRNA products, and the Crown has
Yes.
not objected. Neither is the court. So
Yeah.
that's what they were. And so, yeah, so
And
we're very confident in mootness, but yeah, it does seem to, there does seem to be an ideological bias within the judicial system over what they tend to find important or live, or so keep that in mind.
Mhm.
But yeah, certainly I think with administrative law, I think it's certainly my belief that individuals or groups of engaged citizens um, can navigate their way through these judicial review procedures. With a few, keep it simple. The KISS rule: keep it
Yeah.
simple, be very precise, and before you file in court, make sure you look at the rules, make sure you have a look at all this. If you have questions, go to a university legal aid workshop and ask them the specific questions. Yeah, but it's doable. I mean, like I said, I think your decision there, certainly there are appealable grounds, because the judge in your
Right.
decision, he said that, well, I can't judge the validity of this restriction because it no longer exists. But I mean, the federal court judge in the emergency case just did exactly that. And in fact,
Exactly.
it's a rule of the court. It's the role of the
Yeah.
courts is to ensure constitutional and lawful behavior by the government. And certainly in your
Yes.
case, yeah,
That
it's
was that was
there's
something I stood on as well. It was a principle that I found in some of their again, like some of their own papers, and I think this was actually one of the Nova Scotia courts that wrote this one. But they said in the case of like private standing, well, no, an individual bringing forth a public interest standing, because they were challenging me on standing as well. The paper itself, um, they said that. That it was the right to constitutional behavior on
Mhm.
the part of our public officials that will
Support
support
standing.
standing.
I use the
Yeah.
same citation. Yep, sure.
Yeah, so that's in there as well as a principle. And Tawny is late this morning, ladies and gentlemen. So Tawny, you owe me some push-ups. Drop and give me 10. There are some other really great issues that you raise in your case as well. I was reading, William and I have been comparing notes, so I've read through his stuff and he's read through mine. Yeah, there was also the issue of the consent of minors,
Mhm.
where yeah, go ahead, tell us a little bit about that.
Well, so my original submission, um, I had actually not yet spotted the Ultra Vires part. That was Tamara Ibram, whom you know, I think, quite well, who actually spotted that in the Health Act. So originally, my thought to go in was on bad faith and concentrating on minors, because um, minors, at that time in 2021, before the release of the Pfizer docs and anything, the data I did have would definitely show that children were not at risk from the disease, but were from the vaccine. And so that
Right.
this was unreasonable. So again,
Mhm.
we've gone through a couple of iterations. So the amended version now before the courts alleges ultra vires and bad faith action. The original one alleged bad faith. Um, yeah, so children are afforded under what is referred to as just cogens, which is it's held to be common to any civilized jurisdiction of law. Children are afforded special protections, and in fact, the Children and Family Services Act of Nova Scotia quotes the International Convention on the Rights of the Child in its preamble. And so what Strang did here is, he, in his mandate in Nova Scotia, he aimed it at everyone 12 years old and older. He had
Mhm.
already issued instructions to public health officials and anyone giving vaccines, which I think they were just hiring people off the streets at some points, um, that they could make the decision for the child, if the child came in and wanted the vaccine, even if the parent didn't consent, even if they didn't want him to get it, the child could make the decision if the person giving the vaccine figured they could,
Right.
upon meeting them for the first and only time, and after a couple of minutes, somehow determine that this child has the presence of mind to make that decision.
And they're not even
So
physicians.
sure. So we said that he is interfering with parental rights, which it is. There are sections we quote which says that only a court can order a medical treatment for a child against the will of the parent.
Mhm.
Right? And even in the Nova Scotia Health Protection Act, to actually inject an individual or to order someone into to have medical treatment, they can order someone to quarantine. They cannot order you to have medical treatment without going to court. And of course,
Gotcha.
he didn't do that. So with children, he created a situation where uh, he created in these children the legal right to make these medical decisions, but the children have no ability to take recourse against them on their own. We have a minor applicant, co-applicant. He can only be in court with a guardian ad litem, which is an adult human, and that guardian has to have an attorney. Otherwise, a child himself cannot go to court. So there is a legal maxim that says, oh, I can't remember it in Latin, but basically it says no right without recourse. If you have a right to something, you have to have the ability to take recourse if that right is abridged, and a child
Right.
doesn't. And
Right.
we also say that because he's acting in bad faith, that informed consent by anyone was not a possibility.
Right.
Because, and you mentioned Shelley Hipson earlier, the absolute goddess of FOIAs there.
Mhm.
We have communications from just previous to October 2021, where he's having some back and forth with the comms department, the nudge department, and he openly admits he has no idea whether this stuff's effective, and they tell him you can't say that. No, you gotta say this.
Yeah. And that's in their internal correspondence, right?
Yes, we
Yeah.
have internal. Here's something terrifying. So he's up there and I said this in court, day after day after day. This man came on our TVs and he said safe and he said effective, and he could have formed no reasonable belief that they were either, because
Right.
the manufacturer didn't assert so, the sales contract can didn't assert so, and his internal communications indicate he knew it. So we will, in our argument for mootness, we will enter these documents with an affidavit of Dr. Chris Milburn. So I pity the crown cross-examining him, boy. You're in for a ride.
Yeah. Chris is
So yeah,
awesome.
we will enter these documents to prove the seriousness. We have the right to prove the seriousness of the matter, and certainly proof of mens rea to his unlawful behavior, to a guilty mind, to the fact he
Yes.
knew that he was lying, is relevant, and we will enter it. So, yeah, we have internal. Oh, so this is terrifying. We will put in a memo that came around between him and that Shelley Deeks, who was like
Okay.
the vice minister of health, chick trained under Fauci. So anyway, there's a group
Eee.
of them that are in an email chain where they're talking about adverse events in June 2021 before the mandate, right? Those adverse events that he swore up and down were not happening. Well, so between June 7th and June 11th, there were 28 adverse effect reports that actually went through, and there's probably more, but doctors were under pressure not to file anything. So these are ones that actually got filed. Of those 28, 8 were serious. We're talking myocarditis, pericarditis, minor stroke, and 1 death. between the fucking 7th and the 11th of June, 2.5 months before he initiates this goddamn mandate.
Right. So this is 2021. He implemented the vaccine passport on the 1st of November,
October.
2020.
No, 1st October.
1st October? Okay.
First,
Um,
2nd October, beginning of October. Yep. And this
yeah.
is June 2021.
Yeah. So, yeah. And William made reference to a legal principle known as mens rea, as in a guilty mind. It's basically your competence to stand trial. It's you would have to have the intent to commit the act, as in, you knowingly did wrong.
In the criminal law, yeah, in the criminal law, it's used a lot, but it's not. The only difference between criminal and civil law is the parens parenti role that the state takes in criminal law, where they pursue the person for you rather than you pursuing them as you do in civil law. But
Mhm.
yeah, so basically what we're saying is he didn't make a mistake. He knowingly did these things. He knowingly said it was safe and effective in furtherance, as an act in furtherance of his ultra vires mandate, and that
Mhm.
that is an act of bad faith,
Yeah,
right?
absolutely.
So yeah, so we will enter before the court solid evidence, not only that he knew that they did not work, but that he knew they were dangerous, and there will be
And
he can reply to that.
you would have gotten disclosure, obviously. One
Well,
thing
we
I
got
guess I'm go ahead.
well, I guess let's go through that for everybody. So when you go in for judicial review, you apply for judicial review. The first thing that's supposed to happen is within 10 days, the Crown is supposed to surrender what's called the record, and that forms your disclosure in this proceeding. The record is supposed to contain all the material that the decision maker relied on to make the decision, or at least they say they did.
Right.
But you are not, even in Nova Scotia civil procedure, and I believe it's the same in other provinces, you may apply to enter evidence that is beyond the record. And one of the arguments to do so is bad faith action on the administrator's part. Because I mean, it's pretty simple to understand. If I'm the administrator and somebody calls me on something I did and it's judicial review time, it's up to me to submit what I say I relied on. So if I'm acting in bad faith, I'm obviously going to cook that,
Hmm.
right? So then the applicant so you can introduce, in our case, what they did, and it was a bit our fault, I suppose, in the form of submission, but they dumped 8 gigabytes of crap on our heads.
Yeah.
200. I think Samin was on the Rebel there a couple of days ago, and I think she said there were 200 and some thousand, or no, 28,000 documents.
Yeah.
But of that, something like 30-40% were screenshots of shit from the WHO and Health Canada. And there was the only science we found, and I have an educational background, biochemistry, so I can at least say what is or isn't. There
Hmm.
was no peer-reviewed nothing in there. The closest thing to science we found was epidemiological reports from the Nova Scotia Health themselves, and the ladies who are, they're high-end administrators in their real lives. They crunch the numbers, and all it shows is that there was never a dangerous pandemic in Nova Scotia. And
Yeah.
I said this in court. I said to the judge, they show this, and this is not a scientific argument. This is an argument that can be won with grade 8 math,
Hmm.
right? We don't need to get experts in here. It's apparent. Yeah.
Well,
So
no, I mean, I was crunching some statistics myself for some of my own court appearances, because I have the one on masks coming up as well, and I was looking at the numbers, and there were something like 130 COVID deaths, which is not to say deaths from COVID. I think,
yeah,
as everybody understands, these are positive PCR tests on cadavers,
yeah.
the PCR test is notoriously
Oh, your sound cut out.
on.
Ah, gotcha.
Yeah, I'm not sure. Sometimes I get gremlins, and I haven't quite figured out where they are. But yeah, I was just saying, you know, the COVID deaths, quote unquote COVID deaths, which are positive PCR tests on cadavers, totaled in the number of somewhere around 130 for 2020 and 2021, whereas the 2018-2019 flu seasons actually had a higher death count than COVID did.
Sure,
But
and
guess
as you
what?
say, it's death with COVID, and I don't know if you
Yes.
got it. So the PCR's junk, and Nova Scotia Health itself, about 3 weeks ago, just issued a directive that the those rapid antigen rat tests are completely worthless, and you should
Yeah.
throw them all away.
Yeah. So there's that component to it, but then you know we can see that the previous two flu seasons were actually
Yeah,
more deadly than the
yeah,
so-called COVID seasons,
yeah.
and after the vaccine rollout, as in like the data from 2022, we saw 10 times the number of COVID fatalities as we did in
Mhm.
the previous year. So. And that's what we've been seeing across the board as well. Like the death toll continues to climb year by year ever since the
Well,
rollout.
here's a fun possibility. I'm not saying we will or won't do this, but you can take someone for judicial review for something they've done or something they should be doing. You can actually go in for either judicial review or on application, which is like an application for an injunction. And you can ask the judge to issue what's called a writ of mandamus, which forces a person to do something to force because what's potential here in Nova Scotia is, according to Dr. Milburn and his associates, which are all high end medical professionals, this is off the charts. The unexplained death is off the charts.
Mhm.
And Nova Scotia Health has a legal responsibility to be looking into that, and they're not.
I remember even the CBC reported on that probably in 2022. I want to say it might have been
Well, but
2023
they
actually.
keep the balls in the air. Now it's Gaza and Ukraine, and
Wow, yeah. But and I think too, I think it was CBC Nova Scotia that published it, and it's one of these things. This is what the CBC will do. Something that should be headline news, something that should be front page. They'll just kind of bury it down on page 21. So when people come back to them and said you should have been reporting on this, they'll be like,
yeah,
"We
oh,
did.
we
Look,
did.
it's yeah, it's right there in the footnotes." And the headline was Nova Scotia tight-lipped about sudden spike in deaths. I wonder why the province would be tight-lipped about a thing like that.
Sure. So
Yeah.
so their judicial review application or a direct lawsuit of some sort against the government are all things that are, well, in my belief, within the capability of groups, probably ideally, of motivated and educated citizens. There's no reason we can't do this.
Right.
And I will tell you this, like when we're in, so we have private standing, we're asking for public standing. And the Crown made vociferous arguments about the fact that public standing has never been granted to a self-represented litigant. So if we are granted it, it will be a precedent.
That would be fabulous. Yeah.
The judge asked him on a couple of different occasions, do you have any law that says I may not do this or should not do this? Do you have any law that says it can't be done? And he
Right.
was like, no, no, no.
Well, that's a good sign.
Mhm.
And you and I were messaging there recently. Did the Crown use the dismissal of my recent application for judicial review with respect to the climate lockdowns there as precedent for dismissing yours as mootness?
Ah, I don't think I can comment on that publicly.
Okay,
It
all
wasn't
right.
a public filing,
Okay.
so I have no comment.
All
Um,
right, fair enough.
yeah, I can't.
But
Sorry.
that would be a really greasy thing to do, I think.
Like, it, if it's something that's being done, it would be greasy as fuck. But I have no position on whether it is or not being done. Sorry.
Roger
Um,
that. No, it's all
okay.
good, brother. I don't want to get you
Yeah.
into any kind of hot water. You got enough challenges before you as it is.
Well, you know
Uh,
what I found out? Here's something you should do for sure. Have you ordered the transcript from your proceeding that you got
no, I
knocked
should.
out? Yeah, you definitely should, because before proceeding, if you decide to appeal it, you should have the transcript. But weirdly, so they'll just send you an audio file. They don't actually type it out for you. They send you an audio file. You're not allowed to publish it in any way.
Huh.
So just, I wanted to give you a heads up on that in case if you do get it, you can't put it on you can transcribe it and, read from it or something, but you can't publish the actual audio. So just be
Huh.
aware. I don't know why that would be, even though like there's no restrictions on our case. Obviously there's no, what do they call that?
Publication ban?
Yes, exactly. There's none of that. The only restriction is the fact that obviously the minor applicant is JM and only JM.
Yeah.
But
yeah. And I wanted to go back to the point, because I think I saw something in there about like there's this delegation of enforcement, and also the fact that they were using pharmacists and other people who are not doctors, like there's to administer the vaccines. Now, how does that play into it?
Well, I mean, what we're saying is that part of our argument here is that direction was issued under Robert Strang's signature maybe 4 or 5 months before the mandates came down, that talked about mature minor consent to receiving vaccines. And it directed, as I said, that from 12 years old and up, as long as and again, like you said, this is being given out by pharmacists, and I don't know who was at these max vaccination clinics, like I guess public health guys, but public health workers, not necessarily medically trained. Let's be clear. So the fact that these people were then delegated by him somehow, and he has no authority to do that. He's not the attorney general or a judge. He delegated these people to make a legal decision on the capability of consent to these children. He had no right to do that. None.
Right. And does that, I guess, does that like absolve them of any kind of like, legal ramifications that might exist had they been a licensed physician?
Oh, the individual who might have done this directly?
Yeah.
I would say that they enjoy no legal protection. Right. I mean, if you were injured, you could possibly just civilly pursue the person who directly did that, and especially if they're not a trained physician. The College of Physicians and Surgeons, like, I mean, this is I don't know. I don't know. You'd have to. It's not something I've looked into, but yeah, possibly, because nobody should have accepted that responsibility being put on them by Strang, because he didn't have any authority to do that.
Yeah, and on that, I mean, they've kind of painted these public health orders as having the color of law. I noticed that you pointed out that these public health orders that were issued by a bureaucrat were published in the Gazette. You want to explain the implications of that?
Yeah, well, again, that Terry Abraham spotted this, and so what it is, whenever there's a bill passed, like a law passed, and various other things, or an order in council, even, this is written in what's called the Hansard of the Gazette. So this is the hard copy of the laws of the land. And for some reason, well, we know why, but in cases like your upcoming mass case, and Tara also helps out a lot of people in Halifax who are going for various fines, and the Crown kind of relies on referring to this as a regulation, right? Because the laws and the regulations are published in the Gazette, but the pronouncements of Robert Strang never had the color of regulation or the color of law. Now, an important thing for people out there to note is that, who's that nasty little redhead goof that was the premier for about 10 minutes? What the fuck's his name?
In Nova Scotia?
Yeah.
Must
little
have been while I
redhead
was away in the
weasel
military.
between Houston and the other fella.
I have no idea.
Who's that redhead liberal guy? But anyway, that redhead liberal guy, it has a private member's bill in front of the Nova Scotia legislature right now to make the chief officer of public health a parliamentary officer in the same way that the chief of elections is. If that happens, then his pronouncements would have the weight of law. So they obviously realize. So yeah, like in your upcoming mask thing, if they refer to this as a regulation, you can rip them up, because it doesn't matter if it's in the Gazette, it shouldn't be there. And they have no explanation as to why it is.
Yeah, and
But they did it, one thing, so that they could do exactly this, rely on it. But it's not correct, because there are only certain things that can go in there.
sounds like that soulless redhead is marked with the color of his master.
Yeah. Oh, I can't remember his damn name, but yeah. So he's got that. He's well, but it's not. I mean, this isn't a political party thing, because look at Tim Houston's supposedly a conservative.
Right.
He's
That
the one
was something that happened in Nova Scotia
He's
too.
the
Like
one
we,
that
we
was
changed
there.
governments.
Yeah, but it didn't change a damn thing. That shows you kind of the libcon, I guess, is in that in our case here, the liberal guy got voted out for Tim Houston, who's a bag man mentioned in the Panama Papers, and there wasn't even a heartbeat, and it was Houston who, and I didn't even remember seeing this, but the Rebel News used it when they interviewed Terrence Mean.
Rankin.
Him up. Yeah, it wasn't. No, Rankin. That's the name of that little redhead goofball. So
Thanks,
he's
Mike.
got a private member's bill to do that. But Houston is the one that sat there at the table and said, "Well, that's it. Time's up. Behavior has consequences." The day they introduced the vaccine mandate.
Yeah, that.
Tell you what, Jimmy. Tell you what, buddy. You got part of that right. Behavior does have consequences, Timmy, and you're about to find out. You little shit. But yeah,
honestly.
so yeah, we feel very confident, and what we're hoping to do in the very near future is have a resource page on our Citizens Alliance Nova Scotia website, and you'd be welcome to contribute to it. Resources for self-representation, right? Because we don't want to fish for everybody in Nova Scotia. We want to teach everybody in Nova Scotia how to fish. Or kick the government's ass, whatever takes your fancy.
Well, that's the thing, is they're all in it together. So,
They are.
Good luck even getting a lawyer to take you seriously in this regard. Like, he's not going to go
And
against the
they'll
system.
bankrupt you. Like,
Yeah,
we did have I'm not going to talk about too much, but for a short period of time, we had an attorney, didn't work out. But so we kind of went looking for a new attorney. For the work that we ourselves have done in the last, say, 5-6 months here, the motions and all that, we were quoted $23,000, but we could make it in 3 easy payments of 8,000 something.
Oh yeah, super easy.
A lot of fucking money.
I know.
And I pointed out to the court too that like the Crown kept saying, well, anybody, if they had a problem, they could have sued then. That's not true. The lawyers wouldn't take the case. And I pointed, the lawyers wouldn't take the case. And a lot of the people directly affected by this lost their damn jobs. So the Crown's assertion, my lord, because you got to call the judges here, my lord. The Crown's assertion, my lord, that any person could have ran off and got a $300 an hour lawyer and then proceeded to sue the power of the state is ridiculous, and it's insulting, right? The actions that we're here about took these people's jobs, so it very much took their ability to engage a lawyer. They were
access to justice,
pay their mortgage and feed their damn kids, right?
Yeah.
Ugh. So
exactly.
I think that's where I see, besides the specifics of your case or my case, that's where I see we can have a real and broad effect here. If we can prove concept that either individuals or groups, and of course, if we all start sharing resources, sharing experience, sharing knowledge, creating our own networks, then I think we can support challenge across the board, challenge on the education system, which is
Yeah.
something that Citizens Alliance is very much engaged in and will
Good.
be moving on decisively in the very near future.
Good.
So, but there, it's across the board. Tara really summed it up well, and I'm going to have to kick off here pretty quick. But
Sure.
Tara Ibrahim really summed it up on the Rebel News when she said, "Listen, this is just the tip of the iceberg kind of vaccines. I mean, they're coming across the board, 15 minutes, you name it, they're coming at you." And so we have to get engaged, and if we can use the legal process to do that, it's a tool in our arsenal. It's not the only tool, and of course, yeah, getting out in the streets, media, all of that is important. But this will lend an entire new facet to the battle space that we can start bringing toward down.
Yeah. And I would just reiterate, I guess, that this is the key battle space now, folks. It's in the courts. And before you go, William, there were a couple other things like, I saw you guys addressing this false claim of asymptomatic spread on the part of Dr. Strang. And also, like, what did you find in those 2,800 pages or whatever it was in terms of like the actual risk assessment? Because we're talking about,
None.
yeah,
Zero.
especially as it pertains to the kids.
Never. That's one of the points Chris Milburn, Dr. Milburn makes, is that there's none. There's no risk benefit analysis done at all. Or at least that's what they say, because they say they've given us everything, so you didn't do it then. That's what
and it's not as if Strang personally relied on 2,800 pages in forming his decision. Like, they have an entire bureaucracy established to make briefing notes and this kind of thing, right?
Sure. Well, one of the other lady on the board, Sameen, she made very good points, because again, she's a high-end administrative type herself. So what she didn't see in this collection is, normally you take all these different data points and people in the department are going to analyze that and produce analytic papers, and that's what gets before the decision maker. Hey, I looked at all this, and hey, I looked at all this. This is what our conclusions are from that. There's none of that.
Unbelievable.
None. So one of the things we're saying, one of the sort of side things, but one of the things we're saying is that the record would indicate that Robert Strang unlawfully abjured his authority. He, and only he, as that horrid case in Alberta said, he and only he can make these decisions, and he cannot have undue outside influence. And basically what we're seeing is that not only in his actions, but in the words he spoke, he was directly being informed or told what to do by the feds. But he can't do that. He can't rely on that. He cannot, in our matter, point at the Canada Health and say, oh, well, because they said no. Because constitutionally it's the province, and in the Health Act, he and only he is the one empowered to make these decisions. So if he indeed wasn't making decisions, but simply carrying out the instructions of an extrajudicial or an extra territorial body, even if it is Canadian, he's toast.
Good. And I saw a similar thing. I'll just throw this on your plate here. But I did a FOI pop when I was doing my challenge to the mask mandate for the fine that I have to answer for here shortly. And what they provided me in the way of evidence when they're making this determination about the mask mandate was strictly just this report from the WHO. Wasn't done by the province. It was straight from the WHO. And, I actually went through it, and I found that even the WHO determined that that masks had a low probability of curbing the spread. And another thing that they determined to have a low probability was the use of face shields or goggles. It was goggles.
I love the people that wore both. They were my favorites.
Honest to God. And Yeah, we don't call them COVIDiots for nothing, but that was part of the argument that I made. I was like, well, okay, this just goes to show you the kind of arbitrarity behind this decision making, because they didn't mandate that we have to wear goggles. They only mandated that we had to wear masks, whereas both were assessed with the same level of confidence in their ability to curb the spread. So
Sure, and
just
there's 2 cases in Ontario from 2015. That's what killed me. 2015 and 2018, twice in a row. The Nurses Federation in Ontario. Oh, the kids arrived. Won cases against a vax or mask mandate in Ontario hospitals, and the adjudicators were like, "Yeah, we were really surprised that the hospitals actually could show absolutely no evidence that this worked at all. There didn't seem to be any basis for their decision, whereas the Nurses Association handily showed that it does not. Masks in a hospital setting, the actual use of a mask is so that spittle and crap out of your mouth, especially if you're over someone with an open wound, doesn't get in it. That's it.
exactly.
It doesn't give you any other it doesn't actually protect the wearer from anything, and it never
No,
can.
no.
So yeah,
And
no, it's
yeah, even the
so
best
that's why it's
masks.
important we keep on them.
Yeah, exactly. And
Yeah.
even the best masks, just on that note as well, like they'll list them as a microweave, as in like thousandths of a meter. A micro is a thousandth of a meter. So the opening in the mask is a thousandth, and we're talking about stopping a nanoparticle, which is a millionth of a
Microns.
meter.
Yeah, microns. Yeah, yeah.
Yeah,
Well,
yeah.
it was always ridiculous. But
No, billionth.
what I think the case here and some of the cases in the other jurisdictions have shown is that yes, indeed, there was a top-down plan from the very beginning that included all this crap, and it came down through everybody's various health orgs without it just came direct, and yeah, it came from the WHO, that
The
event
Chinese
I
controlled
wrote
WHO.
down. Yeah, sure, sure.
Yeah.
So and yeah, so that the deeper questions about what was this really about, obviously not the flu.
Mhm.
But yeah, I mean, I think for sure we're gonna. I have every confidence we're gonna get to review, and I have every confidence we're gonna win. And to my mind, for sure, because of this, what this does, the situation you've described, what it does allow is a lot of allegations of bad faith,
Right.
right? That you had no reasonable belief to say this or to do this, but yet you said it and you did it. So
Yeah.
therefore, you had yeah, basically impure motives or bad faith. It was done in bad faith. And that way you go after the individuals, right? Because me and you both work for the government, right? We're driving down the highway in our fucking army truck and we run over some poor bastard. Ah, not my problem. It's the army's problem, right? They're gonna sue the army. The army might kick your ass, might not, but they're gonna sue the army because you the
Yeah.
crown. Right. So it's the same thing. These people, if we can get the fear into some of these people
Right.
that no, maybe you directly are going to have to answer for what you've done. Right.
Yeah.
Like we very much intend to take Dr. Strang's house and his ability to make any money, or his grandkids'
Yeah.
ability to make any money without us getting a cut. This is
Good.
going to be hard punishment. And when they see that, maybe the next guy is going to think twice before he, goes along with it, no matter
Exactly.
who has a tape of them doing what.
An example needs to be set. No question.
Absolutely.
Yeah. Folks, I'll direct you over to the Citizens Alliance of Nova Scotia website here, standing for the rights of Nova Scotians. You can sign up for their newsletter here, volunteer here, and donate here. I'm sure they could use all the help they can get. So,
Certainly,
by all means.
we love volunteers. Like that's the good part about not having to raise so much for legal fees. What we're looking for your passion, your ideas, more than we're looking for your money.
I can't believe I haven't signed up yet now that you mention it.
Well, the bigger the web of people, and like the Crown questioned us a bit, this little group and they're new, and I said, we have a web of people that includes the guy who invented MNRA, right? He ain't from Nova Scotia, but so the broader our base of expertise and knowledge that comes from the citizens, we will absolutely, and that's exactly what Tamara Litch said.
Mhm.
You know, why them Greeks so tough? Who's in charge of them? They're leading themselves, right? So if we can get a bunch of, so yeah, if anybody we're definitely looking at gender and the racism being taught in schools, and we are very much going to take action in the very near future. So if that's something that interests anybody out there,
Yep.
please get a hold of us and sign up.
Yeah, will do. I think I will do that today, actually. Yeah, I'm looking forward to getting engaged there. It's just it's a bit astonishing to me. I guess it's just sort of the fog of war. Yeah, I should totally sign up for this. And also, they're available on X here, Citizens Alliance of Nova Scotia, if you want to follow them for some updates. And I know that everybody loves Facebook. That's where a lot of people are coming together in the freedom space as well. So they have a Facebook page as well. Go ahead and give them a follow there. And by all means, give us a follow as well. Veterans for Freedom. Here's our website. And you can subscribe to our newsletter here. Join Veterans for Freedom if you're a veteran here, and support Veterans for Freedom here by either donating to help us keep the lights on, pay for my StreamYard account, so on and so forth. Or you can donate to the support fund, and everybody who does gets a chance to vote on where the pool of funds goes every month. We got Chris Lysak, fresh out of jail, up this month, so you can go ahead and vote for Chris, and we'll make sure that that goes toward paying his legal fees if they aren't paid off already, or as Drew said during the sit rep that he gave on Sunday, you know, maybe it'd just be to take his family out for a nice meal after being deprived of their father for the last couple of years. You know, that's fine with us as well. Kayla Pollock, she's up here, and we're funding her the Canadian Independence Cause to do a full video coverage of her story. She became a quadriplegic after her COVID-19 booster shot. So yeah, honest to God. And Lisa Robinson is back with us.
I've run into her on X. Yeah.
I met her in Toronto at the Save Canada and Billboard Chris protest, where the union showed up with Antifa shoulder to shoulder to prevent us from demonstrating in front of the school. And yeah, so for those of you who aren't aware, Lisa's been sanctioned 90 days wages for standing up for her constituents and all of this. And she's a single mother as well. So that really hurts. And also we have, you'll have the chance to give 10% of your donations to the Veterans Association Food Bank this month as well. So all kinds of worthy causes there, guys. We got all the buttons set up for you here to do a monthly donation from your credit card. If you don't want to use your credit card, then please send your donation to your e-transfer to fund@veteransforfreedom.ca. That's fund@veterans4freedom.ca, preferably with the auto deposit enabled. But if you're not able to do that, then please use the password fund for freedom. That's all caps fund, number 4, all caps freedom, and we'll make sure that that gets off to a worthy cause indeed. And that brings us all the way back around to Plato. He says the worst kind of injustice is pretend justice. And I'm afraid that's kind of what we're up against here. William, wouldn't you agree?
I would indeed.
All right. Well, we really appreciate it.
We're going to get them.
Yeah, it's just a matter of time, folks. We're going to get mixed results out of the courts, but that is the key battle space, and the tide is turning, as we can see with some of these recent decisions, especially coming from the federal court's declaration of the Emergency Measures Act invocation being Ultra Vires, and also with the release of a couple of the Coots boys. I think these are pretty huge decisions, and perceptions are changing. The tide is turning. And it's always a pleasure to have William on board here with us. He's a happy warrior, I can tell, as so many veterans are. So thanks, William. I really appreciate you taking the time, man, being so generous with it. And I'll let you get to the kiddos there.
Okay, you betcha. You have a great day, sir.
All right, take care, brother.
Won't you help to sing these songs of freedom? It's all I ever have. Redemption songs.